So, Mr. Zahn, we'll have you sit still someplace as we call your case. All right, Mr. Zahn, can you hear me?
Yeah, I can hear you.
All right, I'll have you sit someplace just
Okay.
so you can be stagnant while we do your sentencing.
Okay. I'm new at this Zoom thing, so I'm trying.
All right.
All right. Here, I got a space to sit. Sitting in the front row.
All right. We're on the docket in 22-00941. Well, the parties. Please introduce themselves for the record.
Yes, good morning, Your Honor. Assistant Public Defender Stephen Feigelson, appearing on behalf of Mr. Zahn this morning for sentencing. He is here via Zoom this morning, Your Honor.
Sir, you are Scott Zahn?
Yes, sir.
All right. And you can hear me all right, Mr. Zahn? Mr. Zahn, you can hear me all right?
Yeah, it's kind of fading in and out. All right, I can now.
All right, this is the time set for preliminary for sentencing in this matter. And there's been a City of Lansing pre-sentence report prepared for the court that I've reviewed. Mr. Feigelson, have you had the opportunity to review the report and go over it with your client?
I have, Your Honor.
And are there any deletions, additions, or corrections?
None to the report, Your Honor.
All right. As to allocution?
Yes, Your Honor, a couple of things. Mr. Zahn is at Rice House recovering from his addiction with alcohol, Your Honor. He's doing very well there, Your Honor. He is receiving his monthly disability and food stamps, Your Honor. He is willing to do the things that are necessary on probation. He knows he made a poor choice that night and he wishes he could have handled things differently. He knows now he would have. A couple of things with regards to their recommendation. They're asking for a 4-month term of probation. While I do believe probation is appropriate, I'd ask for a shorter probationary term, perhaps maybe a 1-year probationary term, Your Honor. He is willing to sign any releases at Rise so that any testing and any information that he has at Rise or wherever he goes next will get transferred over to his probation officer here, Your Honor. So we need to do that. Other than that, Your Honor, that's what we'd ask for today. Thank you.
All right. Mr. Zahn, anything you'd like to say before the court passes sentence?
Yes, Your Honor. Since I've been here at Rise, I have done like a 360 turnaround. I'm now the leader of the house that I stay in. I'm working on getting a job at Peckham. Also, all my drops have been clean. I've been hitting about 3 meetings a day. I've been a part of the community, encouraging others. I'm waiting for the PRC class to start up, which is peer recovery coach. And I just got another job opportunity at Hawk Island the other day. I'm just waiting on sentencing and to figure out what times I'll be available. I'm trying to get in there. I'm pretty sure I'm going to get in there, but you know, it is what it is. Also, CMH even wants me to come work as a PRC for them. I talked with the boss of the program there. And
We might have
he's
lost
like,
you, Mr.
well,
Zahn. Okay, go
let
ahead.
me know.
Go ahead.
Uh, when you get rallied.
Mr. Zahn, I think we lost you. Are you still there? Let's wait a second, see if he unfreezes. Okay, Mr. Zahn, we lost you on that last sentence.
Oh, like I was saying, CMH, my old recovery coach at Rick Tripp, his boss was standing there at the rally down at the Capitol, and he heard my story, and he's like, "I want you to come work for me." I'm like, "Me work at CMH? Really?" You know, it pays off when you get your life straightened out and you realize you're wrong and you're trying to correct everything about you, and you move forward.
All right.
And
All right, thank you, Mr. Zahn. So I'm going to adopt the recommendation of the pre-sentence investigation and the JOS commitment to jail. This is on the count 1, plead guilty, aggravated assault. I'm going to, and the recommendation is to spend 365 days in jail beginning July 21st, 2022. Credit is given for 1 day previously served. Suspend 364 days upon successful completion of probation. I feel that Mr. Zahn has earned this sentence in order to complete probation and have the opportunity to complete probation. I will note for the record, this is an aggravated assault, so it's a 1 year. It's the highest 1 year misdemeanor that somebody can be charged with. So count 1 will be on that aggravated assault. I'm gonna place fines and costs at $250 fine and $250 cost for 500. Crime victims' rights fee of $75. State minimum cost of $50. I believe that we can have an accurate assessment of Mr. Zahn's performance on probation at I'll cut it to 18 months as opposed to 24 months. Which would mean that it would be 18 times 30. So it'd be $540 for probation costs. And since we have assessed some fines and costs, that'll knock down your probation rate at $30 a month. No assaultive behavior, assaultive or threatening behavior during the term of the sentence. No use of possession, alcohol, marijuana, or controlled substance. Which is part of the reason why we're here. Submit to random PBTs and urinalysis at the direction of your probation agent. And really the key here, Mr. Zahn, is just keeping in contact with your probation agent so that you always know what's going on and what your requirements are. No bars or nightclubs. Complete intensive outpatient, which you've already talked highly about. And then complete mental health counseling is directed by your probation. As a part of your 18-month probation, you're not to purchase or possess any firearms, ammunition, or weapons of any kind. Mr. Zahn, it sounds like you're doing well, and this is probably a crux for you in a lifetime in regards to prior conduct and post conduct after some of this rehabilitation, and especially after this IOP. So it sounds like you understand what a big and meaningful event successful probation will be. And therefore, it's not to be taken lightly. It's always to have the most priority. Do you understand that, sir?
yes, sir.
All right. Anything concerning the judgment of sentence, Mr. Feigl?
No, Your Honor, thank you.
Anything, Mr. Zahn?
No, but I am on a fixed income, and I guess I discussed that with my probation officer.
Yeah,
About the
you
drop.
can, and they'll set up a payment plan for you.
Okay.
All right.
All
I
right,
think
well,
he's
thank
talking
you,
about
Your
the
Honor.
drops, Your Honor, but I think if he's testing through RISE, he shouldn't have to test twice as long as he does releases.
Absolutely correct. You're absolutely correct. So bring this all up with your probation officer, but I believe Mr. Feigelson's correct in regards to testing. That one test should suffice at the probation officer's request.
You just need to sign releases so that RISE and your probation officer can communicate.
All right. That's all on the record,
Okay.
22-00941. Thank you, Mr. Feigelson.
Thank you.
Good luck to you, Mr. Zahn.
Thank you, Your Honor.
All right, we're all set. Oh, you can leave, Mr. Zahn. You're all set. Right. So we're on the record. We're on the record in docket 22-00830. Will the parties please introduce themselves for the record?
Chris Martin for the people. Good morning, Your Honor. Jacob Starks, the Fourth Assistant Public Defender, here on behalf of Demetrius Hamilton. He's present in the courtroom. He's standing to my left in the jury, in the jury box. Your Honor.
All right. And sir, you are Demetrius D. Hamilton?
Yes, sir.
All right. This is the time set for a preliminary examination. How are we proceeding, Mr. Martin?
Your Honor, that's correct. This matter was set for a preliminary examination. And as the court may be aware, Mr. Hamilton is currently serving a sentence in the Michigan Department of Corrections. At one point, we had discussed the possibility of doing a felony plea in the district court, but upon further discussion with Mr. Sards, we believe that it's in the interest of justice to simply resolve this matter with a misdemeanor plea. And I'm happy to put the terms of that plea on the record.
All right. That's your understanding, Mr. Sarks?
Yes, Your Honor. And if Your Honor is agreeable to this, I would request same-day sentencing. He's up for parole at the end of August. And if possible, if we close out the file at this stage, it would be a big help here.
All right.
No objection.
No objection? All right. Mr. Martin, what are the nature of the plea?
Yeah, the misdemeanor plea would be to an added count of controlled substance use, specifically heroin, in violation of MCL 333.74042A. That's a 1-year misdemeanor with up to a $2,000 fine, and potential driver's license sanctions pursuant to the statute. There's also an agreement that the defendant will pay cost recovery in the amount of $500 to the Tri-County Metro Narcotics Task Force. And that if the court is inclined to impose a penalty of further incarceration, there's a Killebrew agreement that upfront jail will not exceed his current MDOC sentence. And as Mr. Sarts alluded, he's set to be released on August 31st.
August 31st.
And it would run concurrent to the current.
So that would be,
Yeah, just to clarify, Your Honor, that's when it goes before the parole board. There's no guarantee he would be released. at that
All
point.
right.
Thank you.
So I'll restate the negotiations, and then Mr. Sarts, if you see any, this is a plea to use of heroin. And it is a 1 year and or $2,000 fine, potential licensing sanctions, pay costs to Tri-County Metro for $500 in recovery. And then the Killebrew is to be, the current Killebrew jail time is to be no more than the current sentence at MDOC.
Correct, Your Honor.
All right. And just so everybody knows, we have an order of fingerprints. He's got to have his fingerprints taken before he leaves for back to MDOC. Mr. Sarts, may I inquire of your client?
Yes, Your Honor. Thank you.
All right. So do you understand, sir, you understand the nature of the plea agreement the lawyers have talked about?
Yes, sir.
All right. The possible penalty in this is 1 year and or $2,000 pursuant to the laws of the state of Michigan. It's under 333.74042A. You understand that?
Yes, sir.
And then there's some Killebrew agreements along with it. The one that's most important for our purposes are that I'm not going to sentence you to any greater than the time that is required at MDOC at this point. And so, so you understand that, sir?
Yes, sir.
Okay. And then there'll be a $500 cost to Tri-County Metro. So if you plead guilty today, you will not have trial of any kind. You'll be giving up some rights in regards to that trial. Do you understand that?
Yes, sir.
All right. You have the right to have witnesses called in your defense. You have the right to cross-examine all witnesses. You have the right to testify or remain silent without an inference being drawn from your silence. You have the right to the presumption of innocence. And you have the right that every element of the crime will be proven against you within a reasonable doubt of the element. Do you understand that? You also have the right to be represented by counsel. You're represented by Mr. Sarts from the Public Defender's Office. Is that correct?
Yes, sir.
All right. I've indicated the plea agreement on the record. Do you waive your right to trial today, and you're pleading guilty to the offense as discussed?
Yes, sir.
And are you pleading guilty because you are guilty?
Yes, sir.
Okay, I'm gonna have you raise your right hand. Okay, do you solemnly swear to tell the truth, the whole truth, and nothing but the truth under the penalty of perjury?
Yes, sir.
Okay, you can put your hand down, sir. I'm gonna bring your attention back to August 19th, 2019. That is at 2601 East Kalamazoo Street in the city of Lansing, Ingham County, state of Michigan. Were you there on that date, sir?
Yes, sir.
Okay, and in count one, did you use the controlled substance of heroin on that date?
Yes, sir.
Why don't you tell me a little bit about that?
I got addicted to heroin. Messing around with a couple of homeboys. Use it on shoot it to a nigga. I just
And you knew it was heroin when you were doing it?
Yes, sir.
Okay. Any questions concerning the factual basis, Mr. Martin?
I believe the court has, we laid a sufficient factual basis.
All right, Mr. Sarts?
No questions, Your Honor. Thank you.
All right. I find your plea to be knowing, voluntarily, and understanding, right? Per request of counsel and without objection, I'll go to immediate sentencing today.
Thank you, Your Honor.
So the court will sentence you to pay, and so that this runs concurrent, but to pay 500 costs of recovery to Tri-County Metro, which we've talked about. That'll be a part of the sentence. I'm assuming that'll be referred to collections. Okay. Based on not knowing when the out date is at this point in time. I'm going to set your jail time to run concurrently with your out date. I think to be safe in this matter, we'll do from now until August 31st. Okay, so that would be the parole date, correct? So
If parole is granted.
if parole is granted, yeah. So that would be, let me do my math here. If we're on the 21st, 41 days. Okay, 41 days. days sentence to run cumulative. I'm sorry, to run concurrent with MDOC sentence. Any questions about the court's immediate sentencing? Mr. Martin,
None, Your Honor.
Mr. Sarts?
For the purposes of the full board, it would be a huge help for Mr. Hamilton if you could get a copy of that judgment sentence.
Is that going? Yeah, I think we can do one. If you give us 5 minutes, we can set one up.
Absolutely. It'll be worth the time, Your Honor.
Yeah, and that way the transition will be smoother. I understand that.
That way the full board can see the outdate, see the case has been resolved. can see
Right,
what the
and then-
sentence is the whole deal. But
Right.
this was back from 2019. It just would be very helpful for Mr. Hamilton to have that in
Yep.
hand.
No, I think that's a good request. We'll make sure he has that in hand, and then you understand that he's got to get his fingerprints before he leaves today. Thank you.
Thank you, Your Honor.
Anything else for the record in docket 22-00830, Mr. Martin,
Nothing from people.
Mr. Sarts?
Nothing further, Your Honor.
All right, Mr. Hamilton, good luck to you, okay? So Mr. Jackson will be calling your case.
He was in
I
the
hear you.
waiting room. Okay.
All right. Do you have video, Mr. Jackson? All right. So I'm going to call to the record docket 2201126. That is People of the State of Michigan versus Douglas Jackson. This is the time set for probable cause hearing. Will the parties please introduce themselves for the record?
Jacob Whiskey on behalf of the city.
Good morning, Your Honor. Jacob Sartz, the Fourth Assistant Public Defender, appearing on behalf of Mr. Jackson. I'm present in the courtroom. Mr. Jackson is appearing by Zoom this morning.
Okay, and sir, you are Douglas Jackson.
Yes, sir.
All right, and you can hear me all right, Mr. Jackson?
Yes, sir, I can.
All right, thank you. This is the time set for a probable cause conference as indicated. Mr. Witzy, how are we proceeding today?
This will remain scheduled for prelim, Your Honor.
Is that your understanding, Mr. Sartz?
That's correct, Your Honor.
All right, so we will leave on for preliminary examination for next week, and that is for July 28th at 8:30. Mr. Sartz, may I inquire your client briefly just to make sure he knows the date?
Yes, Your Honor. Thank you.
Mr. Jackson, you understand that you're to be back in court on July 28th at 8:30.
Yes, sir.
All right, if you have any questions, please keep in contact with your public defender, Mr. Sartz.
Yes, sir.
All right, we'll see you next week on July 28th. That's all for the record in 2201126 for the file. Mr. Witzy, anything else?
No, Your Honor.
Mr. Sartz?
Nothing further.
All
Thank you,
right,
Your Honor.
that's all for the record of this file. You're free to go, Mr. Jackson.
I'll give you a call later, Mr. Jackson. Okay, thank you.
Yes, sir.
Mr.
Thank
Jackson,
you.
you're free to go. All right.
Thank you. I appreciate it.
Mr. Duncan, can you hear me?
So, Mr. Carter, once we get some paperwork together, we're going to call your case next, okay?
Okay, thank you.
All right. You're welcome.
Hello?
Mr. Duncan,
Yes, sir. How you doing?
Okay.
Good morning.
All right.
Can you see yourself on the screen?
Yes, sir.
Okay, try to sit up straight and appropriate, okay?
Mr. Duncan, we're gonna call your case in just a second, all right? So
Yes,
stand
sir.
by.
Yes, sir.
All right. All right, so we're on the record in docket 22-01747. That's people of the state of Michigan versus Terrell Shante Duncan. Will the parties please introduce themselves for the record?
Jacob Whiskey on behalf of the people.
May it please the court, David B. Carter Jr. on behalf of Mr. Duncan, who is appearing by the Zoom app, and we would waive personal appearance.
All right. You are Terrell Duncan, sir?
Yes, sir.
And you can hear me all right, Mr. Duncan?
Yes, sir.
All right, this is the time set for a PCC conference. Mr. Witsi, how are we proceeding today?
The people will be dismissing the case without prejudice, Your Honor, for the interest of justice.
All right. Mr. Carter, I'm going to assume you have no objection to that?
None.
All right. For the record, I've signed a notion, a order of nolle pros in regards to this case. So I'll indicate for the file, plaintiff moves to dismiss without prejudice. Nolle pros has been signed. Mr. Carter, may I inquire of your client briefly just to make sure he knows what the dismissal without prejudice means?
Of course, Your Honor.
Mr. Duncan, today the case has been dismissed by the people in regards to this file 22-01747. It's dismissed without prejudice, which means that the prosecutor could refile if they choose to, but for today's purposes, the case is dismissed. Do you understand that, sir?
Yes, sir.
All right. Anything else for the record in docket 22-01747? Mr. Witsi?
No, Your Honor.
Anything, Mr. Carter?
No, Your Honor.
All right. Mr. Duncan, you should be all set. If you have any questions, keep in contact your lawyer, Mr. Carter. Other than that, you're all set. You can leave the courtroom.
Yes, sir. Thank you.
Thank you.
Thank you. It's good to see you, Mr. Carter.
It's good to see. Well, I can't see you, but it's good to hear you.
All right. Thanks.
Yeah.
Ms. Robinson, are you ready to go on Jennifer Cressman?
Your Honor.
All right. We're going to call to the record docket 22-01345. That's People of the State of Michigan versus Jennifer L. Cressman. Will the parties please introduce themselves for the record?
Jacob Westy on behalf of the people.
Aaron Robinson, Assistant Public Defender on behalf of Ms. Cressman.
And this is the time set for a probable cause hearing. It's 8:30. This was scheduled for 8:30. It's now 9:13. Mr. Witsey, how are we proceeding today?
Your Honor, the people have made an offer that involves this case being handled in mental health court at 55th. I would defer to Ms. Robinson regarding Ms. Cressman's position on that, where she is this morning.
All right. Ms. Robinson, your client's not here today. How are we proceeding?
Yes, Your Honor. So it appears that she is lodged in the Clinton County Jail. I have just been appointed to this case as of yesterday, so I have not received discovery in this matter yet and have not had an opportunity to talk to Ms. Cressman. So at this time, we could just leave it on for preliminary exam, and before the exam, I can go out and talk to Ms. Cressman about the offer once I receive the discovery.
All right. So it's set for prelim on the 28th. So, Mr. Witsey, and the court was certainly unaware that Ms. Cressman is in the Clinton County Jail, so it'll be left on so that counsel can meet with her client and also discuss any discovery issues. That's your understanding today?
Yes, Your Honor.
All right. So we will leave this on for preliminary examination next week. We'll have the defendant writ out of Clinton County. And that should suffice for your time period of meeting with your client. Anything else on the record in 22-01345 from the people?
No, Your Honor.
Ms. Robinson, anything?
Oh, Your Honor, thank you.
All right. That's
Have a
all
good
for
day.
this file. Okay, we're on the record in docket 22-01851. That's People of the State of Michigan versus Karen D. Elston, or Karan D. Elston, I should state. Will the parties please state their appearances for the record?
Jacob Westy on behalf of the people.
Morning, Your Honor. Rico Neal, appearing on behalf of Mr. Elston, who is present via the video system.
Okay, and you are Karan Elston, sir?
Yes, sir.
All right, and you can hear me all right, Mr. Elston?
Yes, sir.
All right, I'm gonna have you speak up as loudly as you can, all right?
Okay.
All right, this is the time set for a probable cause conference. Mr. Witsey, how are we proceeding?
Your Honor, there is an offer. I don't know if the court prefers I ask for a recess to speak with Mr. Neal to discuss that. Would that be appropriate?
Certainly, if you have not had the opportunity to discuss, you can talk to Mr. Neal. Have you had the opportunity to speak with Mr. Witsey?
Yeah, Mr. Wissey and I have not had an opportunity to discuss the offer. My office was just retained on this matter. Yesterday, I have had an opportunity to discuss this matter with my client and the nature and the purpose of the PEC this morning. he understands he has a right to have the exam within the 21 days. Given that we were just retained, we don't have a discovery or anything. As such, my client will be waiving his right to have the exam within the 21-day timeframe. We'll be asking that the prelim be reset.
All right, so let's do this today. I will take the 21-day waiver from your client. That'll give you the opportunity to speak to Mr. Neal, and then we'll get a new prelim date. All right. So may I inquire of your client about the waiver of 21 day?
Yes, you may.
Okay. Mr. Elston, do you understand that you have the right to a preliminary examination? Thank you, sir. You have the right to a preliminary examination within 21 days, which, do you understand you have that right today?
Yes, sir.
Okay, and what that means is you have a right to a prelim within 21 days, and a preliminary examination is a hearing in which the people would have to prove by probable cause evidence that a crime was committed and that you are the person who committed that crime as charged. Do you understand that?
Yes, sir.
And of course, you'd have the right to counsel, and you'd have the right, you're presently represented by attorney Mr. Neal, and he would be able to contest those charges at that preliminary examination, cross-examine any witnesses along those lines. Do you understand that, sir?
Yes, sir.
Today, if you waive your right to a preliminary examination within 21 days, you'd only be waiving that right to have the prelim within 21 days. You would not be waiving your right to a prelim in general. So this is only a waiver of the right within the time period. Do you understand that?
Yes, sir.
All right. Are you willing to waive your right to a preliminary examination within 21 days? So I'll reiterate it again. If you waive your right to have your prelim within 21 days, you're only waiving that right to have your prelim within the time period. You are not waiving your right to have a prelim in general. And this is at the request of your counsel.
Yes.
So are you waiving your right? So do you agree to waive your right to a prelim within the 21-day time period?
Yes.
Okay. So I find the waiver of the right to within 21 days to be knowing, intelligent, and accurately made, and we'll reset the prelim date and it's August 18th. At what time? At 8:30.
Judge, if I may.
You may.
I may be out of town that particular day. I have
Okay.
another different day.
All right. We can make it sooner or later. We can put it on August 11th or the week after, I think.
25th.
All right, let's try the 25th. August. Oh, I'm not here. I'm not here on the 25th.
So we can either do August 11th or July 29th.
So August 11th or July 29th. July 29th, we've already, that's just a week. Yeah. Would the 11th work? Okay. At 8:30. All right. So, Mr. Neal, may I inquire of your client, make sure he knows of the August 11th date?
Sure.
All right, Mr. Ellison, you've waived your right to a prelim within 21 days. We've reset the prelim for August 11th at 8:30. Okay, sir?
Okay.
All right. If you have any questions, please keep in contact with Mr. Neal. All right.
All right.
Is there anything else for the record on docket 22-01-851? Mr. Witzy?
No, Your Honor.
Mr. Neal?
We'll just ask that bond be continued.
Okay. And no objection to that,
No
right?
objection, Your Honor.
All right. With no objection, bond being continued. That's all for the record. Thank you, Mr. Neal, for your appearance. Thank you, Mr. Ellison.
Thank you.
For talking knowledge.
So we're on the record in docket 22-00287. People, the state of Michigan versus Andrew Stewart. This is the time set for a probable cause conference. Just for the record, I'll indicate that we're here at the probable cause conference. The defendant had initially pled or rejected a Killebrew agreement. The court rejected the Killebrew agreement. So the plea was withdrawn and the case was set for probable cause conference today and preliminary examination on July 28th. This case was scheduled for 8:30 today. And it is now 9:30 today. Mr. Witzy, I know this is not your case. I know it's Mr. Fiver's case, but how are we proceeding today?
Your Honor, this would be left on for the preliminary examination.
All right. Are you requesting a bench warrant bond forfeiture? Since I indicated that he needs to be here with lawyer present and he's not here. And I have in my notes that I made it fairly clear he was to at least show up today. Are you requesting a bond forfeiture? You may not have those instructions today.
Your Honor, I would leave that in the court's discretion. I cannot tell from our file if there's any attorney contacted us. I don't know if he's represented. Information I have says he's not.
Okay.
I would leave that in the court's discretion.
Right. I remember the case. I remember having the attorney withdraw. The original attorney was, it was Melissa Patrick. And then I indicated to the defendant that he had to get a lawyer, that he had to be here at the probable cause conference on July 21st, and that we'd set that for prelim. He said he understood. So today I'm going to issue a bench warrant and bond forfeiture for the defendant, as the defendant has failed to appear. And the nature of the allegations in the case, which are a weapons, a felonious assault, and a domestic assault, indicate that no 48-hour hold should be placed. Anything else for the record, Mr. Witzy, in docket 22-00287?
No, Your Honor.
All right. So that's all on the record, Mr. Stewart. Only when I see is Miss Breeze here, I just don't see Mr. Abbott's here. So Ms. Scott, are you there? Bree Scott?
Whenever we're ready.
I lost her.
Yeah.
Bree Scott?
Oh.
Whenever we're ready.
Hello? Can you hear me?
Ms. Scott, yes, Ms. Scott, I'm just indicating to you that your attorney's on his way. So he's in another courtroom. So just stand by, okay?
Okay, yes, because I was wondering, I have not yet talked to my attorney at all and get a hold of him yesterday. And I'm really nervous because I
Okay.
have talked to him.
Okay, I just want to make sure you know you're in the right courtroom, you're in the right place. We're just waiting for your attorney who's in another courtroom, okay?
Yes, Your Honor.
All right.
Thank you.
You're welcome. And you might want to mute yourself just because yeah, we can hear you in the courtroom.
Sorry.
We're on the record in docket 22-01587. That is people of the state of Michigan versus Angelique Redmond. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Good morning, Erin Housefield on behalf of the people.
Good morning, Your Honor. Jacob Starks, the fourth assistant public defender, here on behalf of Ms. Redmond. Ms. Redmond is present at council table. She's standing to my right.
All right, and ma'am, you are Angelique Redmond? Okay. This is the time set for a preliminary examination. Ms. Housefield, how are we proceeding?
Thank you, Your Honor. At this time, the people are unable to proceed with the preliminary examination as I do not have the necessary witnesses. People are moving for a dismissal without prejudice, and I will, if the court will give me just a moment, submit an ollie.
And that's your understanding, Mr. Sarts?
Yes, Your Honor. Thank you. No objection. Ms. Redmond is, and I have additional proceedings, but thank you.
May I approach, Your Honor?
You may.
Thank you.
And then we'll stick around and wait for a signed copy, Your Honor.
All right.
Thank you.
And Ms. Redmond, just an indication today that this is a dismissal without prejudice, so the people could refile if they choose to, but for today's purposes, this case is dismissed. All right, ma'am? All right, thank you.
Thank you, Your Honor. Thank you, Ms. Nesbitt.
It's good there's two of us on that. Let's go on the record in docket 22-00112. That's people of the state of Michigan versus Kevin R. Jackson. Will the parties please introduce themselves for the record?
Morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people. and Assistant Public Defender Scott Nichol on behalf of Mr. Jackson, who is present and sitting in the jury box.
All right, this is the date set for a preliminary examination today. Mr. Pfeiffer, how are we proceeding?
Your Honor, the people are not prepared to proceed today as the witnesses that we subpoenaed are not here, and I frankly do not know why. And it is surprising because I've been in very good contact with the victim. She even emailed me this morning. And apparently, if you remember, this case was initially set for Friday, moved it forward a day so the victim could get to her doctor's appointment for her lung disease. She emailed me this morning that she called the victim hotline number. There was nothing listed for this case, so I think that didn't get moved up a day. Therefore, she didn't think she had to come up here today. I immediately emailed her back, but I haven't gotten any response from her, nor from her phone, which apparently that number no longer is operable. I was also prepared to proceed with just the officer, Officer Rachel Logston. That officer is apparently on light duty, which likely means something regarding medical, and is not answering her phone. It's also been a recent trend where officers who are on light duty don't actually get their subpoenas from LPD, and LPD doesn't tell me. I found this out from a different officer who just happened to be here in the jury room back there. So the long story short is, I do not have witnesses here today who were subpoenaed. I do not know why, particularly given that the victim has been very on board since the day this was issued. There's never been a communication issue until now. And I would ask for a brief 1-week adjournment in order to hold this examination. Otherwise, the people will reissue it. It's not even going to be a question at that point for our office. And we'll be right back here. And I would not prefer that to happen because there is the 180-day notice that's already been filed in this matter. Now, I need to look at the case law as to how it would affect it, but either it would reset his 180 days, which would be good for Mr. Jackson, or we would be under the gun even more, which is also not something that I would like to see happen. So I would be asking for a brief 1-week adjournment in the matter, because that way I can actually get my witnesses here.
Mr. Nichol?
And I would object to the court adjourning this matter. Mr. Jackson is here. I am here today, ready to proceed. The defendant, Mr. Jackson, he has a right to have his exam held within 21 days. Subpoenas were sent out to both witnesses. Mr. Pfeiffer informed me, and I think he informed the court, he did speak with the complaining witness in the case last week after this matter had been moved up a day and made her aware of the different date. So it's not like she wasn't aware of the date and that's why she didn't show up. The prosecutor's office's error in not updating their witness hotline, that's their error. That's not Mr. Jackson's error. And so I would ask the court to dismiss this case at this time. The prosecutor's office is free to handle the case how they wish, at which point at least the 21-day period would reset. And I would ask the court not to adjourn this, not to hold the failure of the prosecution to be able to get its witnesses present in court today against Mr. Jackson.
Any response, Mr. Pfeiffer?
I believe it's good cause, Your Honor, for waiver of 21 days. I would note for the record that the 21-day window ends tomorrow. So there wouldn't be any possible way to reschedule this other than tomorrow, which make things a little difficult because again, the victim would be available in order to be inside that 21-day window. This is not a case where it's been any kind of wishy-washy or communications issue with the complaining victim in the matter. Been remarkably rock steady for my cases.
And this was initially set on July 1st. Probable cause conference was set on July 15th. Preliminary examination was set on July 22nd. And then it was moved to July 21st in order to appease the victim's health concerns. There was a health issue here. So we certainly are we're still within the 21-day period. So the court would have to find good cause in order to adjourn this matter. And if I was going to adjourn this matter, it'd be 1 week. So we'd be right outside of the, we'd adjourn it to the 28th, for this matter. I'm a little concerned that the LPD officer didn't show up, because that, I mean, I can understand the nature of the victim not showing up. The LPD officer not showing up gives this a little bit, but if she's on, if there's light duty and there's some question whether they got the subpoenas, I have an understanding.
It's been a reoccurring issue that I've noticed lately.
I find there is good cause. Good cause to adjourn the matter 1 week. I will indicate for the record that we are looking at multiple counts, 7 counts in regard to this file, and all of them felony counts, at least except for one. So I will adjourn this matter for 1 week to July 28th. I don't expect them to be accommodating us all the time for, and we just did a writ that was way early for them, so that shouldn't be the norm. So I find good cause for at least the complaining witness, definitely because of health problems. We're right at the 21-day level. LPD, that there's a reason why the LPD officer isn't here. But I'm going to adjourn this matter to as soon as possible, which is August 5th at 8:30. Anything else for the record, Mr. Pfeiffer?
Not from the people, Your Honor.
Anything, Mr. Nichol?
Nothing from the defense.
All right.
Obviously, the offer makes sense.
Yeah.
So that's all on the record, docket 22-00112.
Thank you, Your
Thank you.
Honor.
So we're on the record in docket 22-01644. That's people of the state of Michigan versus Paul Holt. So parties, please introduce themselves for the record.
Thank you, Honor. Aaron Housefield on behalf of the people.
Good morning, Your Honor. Jeffrey Rossi on behalf of Paul Holt, standing to my right.
And this is the time set for a preliminary examination in the matter. Ms. Housefield, how are we proceeding?
And thank you, Honor. It's my understanding that defense wishes to unconditionally waive the preliminary examination. The people would also unconditionally waive their right to hold the preliminary examination and ask that the matter be bound over to the circuit court on the complaint as filed. There was an offer extended in this matter for the defendant to plead guilty to an added count 3 of attempt fleeing 4th degree. That would be pursuant to 750.479A2, then a bracketed A, Your Honor, for the attempt.
All right.
The
So
maximum on that would be 1 year and or $1,000. in consideration, the people would dismiss counts 1 and 2.
So that's the offer that, and you're leaving that on the
That
table.
will continue to circulate.
All right, so let me make sure the file indicates that. So it's an amended count 3 of attempt. The attempt, flee and elude.
That's correct, Your Honor, but in the, yeah, the attempt, Your Honor.
And that's a 1 year and the
1 year, 1,000.
1 year, 1,000. And then I'll just, for the record, I'll put the record, what's the MCL code again?
Yes, Your Honor, it's 750.479A2,
Okay,
and then the A for the attempt.
okay. All right, so it's my understanding this is going to be an unconditional waiver bound over as charged, which is on the complaint filed. The offer is left open to the 1 year misdemeanor. Is that your understanding, Mr. Rothstein?
Yes, it is.
May I inquire of your client on the waiver?
Yes.
Okay. Sir, you understand you have the right to a preliminary examination today.
Yes.
And a preliminary examination is an examination in which the probable cause, Ms. Housefield, through their witnesses, would prove that there's probable cause to believe that a crime was committed and probable cause to believe that you committed that crime. Do you understand that?
Yes, sir.
And you have the right to contest those charges through cross-examination. Mr. Rothstein here is your attorney. That would be part of the hearing. Do you understand that? Okay. If you do not have that preliminary examination today, it's my understanding you will waive your right to a preliminary examination, and this will be bound over on the 2 counts that have been alleged against you. One is the 5 year and one is the 2 year stolen, receiving, concealing a motor vehicle is stolen property, which is a 5 year, and flee and elude 4th degree, which is a 2 year. My understanding is the offer is left open in that regard, so you'd bind over in circuit court.
Sorry.
Go ahead.
I'm looking for the charging sheet, because I thought it was just charging fleeing and eluding.
That is flee and eluding in the 4th degree, which is the 2 year, and then RNC on the moped. Those are the alleged charges. That the offer right now is the 1 year misdemeanor. But if you plead guilty, if you bind, the case is bound over today, you'll be bound over on the 2 counts. Do you understand that?
Yes, sir.
All right. Is it your wish today to waive your right to a preliminary examination and to have this case bound over as charged to circuit court?
Yes, sir.
All right. Any questions on the waiver, Ms. Housefield?
No, thank you, Your Honor.
Mr. Rothstein?
No, thank you.
I believe the waiver is done freely, understanding, and voluntarily. We've discussed the plea agreement. Prosecutor also waives their right, and the next date will be set by circuit court. So keep in constant contact with your attorney, Mr. Rothstein. He'll let you know where to be in circuit court, and then I will have the bind over signed. Now that we've done that, we can have the bind over signed by counsel. So it's waived on today's date. Today's the 21st. And I'll have counsel sign. Thank you. Thank you. To hold 22016444 from the people.
No, thank you.
Anything, Mr. Rothstein?
I do not, let me just put on the record, we may be developing an alibi defense. I'm not sure whether I have to put that on the record or not. I'm better safe than sorry.
All right. So that is placed on the record. Without anything further on the file, 22016444. Mr. Holt, have a nice day, all right?
You too, thank you.
Okay. Mr. Raleigh, you're here on Bree Scott from the Public Defender's Office.
Yes, Your Honor, that's correct.
All right, Ms. Scott, are you there?
Ms. Scott, please unmute yourself.
She's trying to unmute herself. I don't think we can unmute her.
Can you hear
There we
me?
go. I can, Ms. Scott, thank you. Ms.
Sorry
Scott,
about
no problem. Mr. Abbott, who's your assigned attorney from the Public Defender's Office, is still in court, but we have Mr. Raleigh from the Public Defender's Office who's going to stand in for him. I'll put you two in a breakout room so he can explain where we're at in the proceeding, and then you can decide how you want to proceed today. But before the prosecutor gets here, let's go ahead and put you in a breakout room with Mr. Raleigh so you can have a discussion, all right?
Okay, thank you.
All right. So I'm gonna have you and Mr. Raleigh placed in room 1. Okay.
That's my goat.
All right, Mr. Wisty, Miss Scott and Mr. Raleigh from the Public Defender's Office are in a breakout room, so I'm letting them talk. And then we'll go on the record on that probable cause conference, okay?
Thank you, Your Honor. I had zoomed in to request if, when Mr. Raleigh returns, if I may have a breakout room with him to reiterate or make an offer on this case.
Perfect, perfect. All right. So yeah, once he comes back, I'll place you and Mr. Raleigh in a breakout room.
Okay, thank you, Your Honor.
You're welcome.
we're fighting.
Mr. Abbott, we're gonna put you in room 1 with your client and Mr. Raleigh, who are meeting right now, okay? I know you were in another courtroom.
We're waiting for Mr. Abbott too.
All right, so let's go ahead and put you in room 1.
Have now with the sound guy wants your song.
Let's go on the record then. And I don't know if Mr. Wisty going to join us by, okay.
I'll just
So
go on
Mr.
the
Wisty, you're
record.
going to join us by Zoom? All right. So we're on the record in docket 22-01695. That's people of the state of Michigan versus Bree Scott. This is the time set for a probable cause conference. Will the parties please introduce themselves for the record?
Jacob Westy on behalf of the people.
Good morning, Your Honor. John Abbott with the Hingham County Public Defender's Office representing Ms. Scott. She appears by video today.
Okay, and you are Bree Scott, ma'am?
Yes, Your Honor.
All right, if you can, I'm gonna have you, I'm barely able to see you, so I'm gonna have you sit up. All right, thank you. This is the time set for a probable cause conference. Mr. Wisty, how are we proceeding?
Your Honor, the people have made an offer to the defense I believe the defense attorney had consulted with his client in Zoom, so I would turn it over to them. How they'd like to proceed after conferring about the offer.
All right, and Mr. Abbott, my understanding is you've had a brief time to talk to your client.
Yes, basically, I said hello and that we're gonna leave it on.
Okay,
And then my battery died. And
okay,
the reason is, Your Honor, I haven't yet received a copy of the police report. And so I really can't make an evaluation of any offer that's been made. So I'd ask the court to leave it on the schedule with the hopes that soon I'll get that police report. And if it looks like accepting the offer is a good idea, I'll advise Mr. Wisty. Otherwise, we'll just expect to hold a preliminary exam.
all right. So it's currently set for July 28th at 8:30.
Be on time.
All right. May I inquire your client, make sure she knows the date, Mr. Abbott?
Thank you.
Ms. Scott, Mr. Abbott was just appointed and is in need of looking at the police report so he can make an evaluation of the offer. So we're leaving this preliminary examination on for July 28th, 2022 at 8:30. Do you understand that, ma'am?
Yes, Your Honor.
All right. In the meantime, you'll have the opportunity to speak to Mr. Abbott and get ready for the hearing on that date. Anything else for the record, Mr. Abbott?
Just, I understand there's some video of this. I'd like to get a look at that as soon as possible.
Mr. Wisty, are you familiar that there's some video with the event?
Yes, Your Honor, and I will provide that to defense counsel as soon as possible.
All right. Thank
Nothing
you.
further.
Anything else, Mr. Wisty, on 2201-695?
No, Your Honor.
All right, Ms. Scott, we'll see you on July 28th at 8:30. Keep in contact with your public defender, Mr. Abbott.
Yes, Your Honor. Thank you.
All right, you're free to leave.
All right.